Just your views on the efficacy of the 16 Days of Activism campaign.
Thank you so much, Austami, for this opportunity, and greeting to all the viewers wherever they are. 16 days of activism, the whole purpose, the effectiveness of the days is to highlight the scourge of gender-based violence in our society. But we know very well these cases of gender-based violence are not only occurring within these 16 days, but it's a 365 days project. So as the foundation, yes, we are remembering whatsoever that is happening within these 16 days to commemorate and to raise awareness about the victims of gender-based violence. But to us, it's not only going to end today, because our fight is still an ongoing battle. It's a 365 days matter.
What we see during this time of the year is extended and intensified media exposure. Everybody's talking about the 16 Days of Activism for No Violence campaign. How is this same sentiment to be carried out throughout the year? How is the momentum to be maintained, and perhaps even beyond just the raising of awareness and beyond speaking about it?
Okay, for an example, on our side, as the One Strong Voice Foundation, we have been holding campaigns previously before the 16 Days of Activism. So it's just to add, it's like dessert to us to say in this fight against gender-based violence, 16 Days of Activism is to escalate the fight, bring more awareness, go to prisons, go to all these people who have perpetrated violence within our society. So for us, this 16 days, it's short. So our programs are to set throughout the year. For an example, we have partnered with other stakeholders, for an example, to highlight these issues. We're still going to be visiting prisons so that this matter is being highlighted, just to get the root cause of gender-based violence. What is it? How can we solve this problem? For an example, today we had a program. We are supposed to be having the Minister of Police, but unfortunately, due to him being so occupied across the country, we were granted the Deputy Minister of Police to address the very same issues of gender-based violence. So it has happened previously that there was a woman who was being beaten by a husband or so. So unfortunately, that woman did not open the case of assault or grievous bodily harm. So we felt as an organization, no, we need to take a stand against these types of acts. So one of our calls on our memorandum that we submitted today to the minister was to say, if, like, for example, when somebody has passed on, like the police are, when somebody was murdered outside, the police are able to open a murder case without the victim being the one opening the case. So our call as the foundation is to say, let police be able to open these cases of gender-based violence, even if the victim does not want to open the case. But should there be any evidence point?
And yes. Perhaps let's bring in Major General Bafana Linda at this point. Major General Bafana Linda is the National Head of Family Violence, Child Protection and Sexual Offences. Thank you very much, Major, for joining us at this time. And you are at the South African Police Services. We're talking now to Mr. Sithole about the importance of ensuring that the 16 Days of Activism campaign is not just limited to this particular time period, but that actually awareness and interventions happen throughout the year. He was also just there at the tail end mentioning the fact of interventions being put in place where police themselves are able to intervene and perhaps open cases even when the victim doesn't open the case themselves. Give us a bit of an update as to how that works and the success of that in the past.
Good afternoon to the listeners, and good afternoon to your studio guest. As you know, that the issue of opening up a case with reference to the current matter which I've dealt with personally myself, that we have the complainant that don't want to open up a case. We don't open up a case for the sake of opening up a case. We rely on the complainant putting up an affidavit. Remember, it's a crime against that individual. If the individual don't want to open up a case, how are you going to try it? Because you need an affidavit, and that person's testimony must be tested in court, because it did not happen in the presence of the police. Yes, if the crime happened in the presence of the police become a complainant. But in this case here, it happened in the absence of the police. We only saw a video recording, and the very same woman went to the police station and said she wants to open up a case against the person who posted the information on social media. So before we can think of changing and how police can do, we must look at our legislation to say, what does the Constitution say about the mandate of the police? We cannot open up a case against a person when someone says, I don't want a case against a person.
Now, because this is a national problem that we are facing, you mentioned something there that if the offence or if the case does not happen in the presence of the police, if there are other witnesses that are they then in a position to open up a case?
Well, I think this is very broad, if we may discuss it. You have an issue of application for a court order. It makes provision that if the victim is under duress, that she cannot be able to move out of the environment to go and open up and apply for a court order. That the person who's a neighbor or who is a relative can open up that kind of application for a court order on behalf of. Coming to this case here, somebody can come and open up a case saying, I've witnessed my mom has been beaten up. That person is a witness. We can. But in a case like this one, we have matters where women come forth and open up cases. Then while we're in the process of investigation, they come back and say, I want to withdraw the case. They've got that right within the Constitution to do so, to make their own decisions. In a matter like this one also, it's the same. Same application. Within the Bill of Rights, the person has the right to come and say, yes, I open up the case. The person can say, no, I don't want to.
Let me bring this back to you, Mr. Sithole. I mean, you're hearing there the Major General talking about one of the dynamics that they encounter where those who are complainants end up withdrawing and not even wanting to lay a case. How prevalent is this in your view, and how can that be circumvented?
Okay, thanks so much, Austami. The thing with the direction that we are coming from, let's say somebody has been murdered, yeah? And then here comes the police to come and remove the forensic pathological services, coming to remove the deceased body, taking to the mortuary. Immediately an inquest or an investigation begins there. So witnesses are called into place. The victim themselves, cannot wake up and go and open the case. The victims themselves cannot make a decision whether they want to open a case against the perpetrator or what. So on the very same basis, we are saying if a state can open a case of somebody who has been murdered, why can't they open a case of somebody who's being violated while they are still alive? Because most of the times these victims are afraid of being threatened or being killed should they go to the police station. So what we are saying as One Strong Voice Foundation is that if the case can be opened of murder, why can't the very same principle or rule be used in the cases related to gender-based violence? That is the angle we are coming from. Let's
give the Major General an opportunity to respond to that. The One Voice Foundation say, why wait until people have died? If you're able to apply that principle on somebody who has been a victim of murder, why can you not do it beforehand? And he's advocating as well for perhaps a change of the laws.
Thank you very much for the question. What one should appraise himself or herself with, we have a common law crimes, which crimes are as a crime against the state. Then you have your statutory law. So domestic violence it's a statutory law. It's not a common law. So common law is a crime against the state. Thou shalt not murder. You can mention all of them. And here we have got a statutory law that is looking at regulating the relationship between the subjects themselves. So we need to understand the principle way it's being applied. That's where we will be able to appreciate, to say this can be there, this cannot be there. On a case of murder, yes, we pursue the case of murder because it's a crime against the state, it's a common law crime. And here we're talking about a statutory law. If we want to make an amendment, I think my colleague over there should lobby the government, and we go back to legislation and make some amendments there. But remember that when we have to convict someone on a trial, you need someone to stand in there and testify, and that person's evidence must be tested by being cross-examined. So on the case of murder, we have more that gives us to death. And on this one here, remember that GPVF is a crime against closed doors, a crime against, it's a crime within closed doors, a crime within the back alleys. So in most cases, we are expecting that particular woman to come forth and give details of what happened.
Major General, unfortunately, we're going to have to leave our conversation there. Time not very much on our side. But I thank you very much for your insight and your contribution in this. That's Major General Bafana Linda, the National Head of Family Violence, Child Protection and Sexual Offences at the South African Police Services. And thank you as well to you, Mr. Brian Sithole, Director of One Strong Voice Foundation. Certainly, I think this conversation, brief as it was, outlines some of the key challenges that are being faced in the meting out of justice, and perhaps where amendments need to be made in order to have a more efficient system under play. So we don't wait for a person to become a victim of murder before witnesses and loved ones are able to step in and intervene there.